of Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I am William Meade. With me on the panel today are Justices Desmond and Hand. We will be the panel for all of the cases today. If you haven't been here before, each side gets 15 minutes. You needn't use all of your time. We do not entertain rebuttal. We have read everything, and it's my best advice that you get right to the point. With that, I'll call our first case is 22P61, Commonwealth versus Sullivan-RODRIGUEZ. Mr. Spavento.
Excuse me. It's the weather. Good morning, Your Honors, on this cold day, and may it please the court. As you just, I'm just going to get right to the point. There's not a lot to talk about this case, but this is how I like to start, Your Honors. Ladies and gentlemen of the jury, we're here today to talk about accountability. Today, she's to be held accountable. I would like you to hold the defendant accountable. Right off the bat, right before any evidence has come in, the prosecutor is already focused on punishment. Make sure that the defendant is here to be punished, not to his constitutional right to be here for a jury trial, not what the facts are, accountability. So the issue in this case, I think the Commonwealth agrees, yes, it was error, but was it a substantial miscarriage of justice because the defendant failed to object?
So the defendant failed to object both to the opening and the closing, correct?
Yes, Your Honor.
All right. But the offense itself occurred right in the police presence, right?
I'm sorry, Your Honor?
The offense itself occurred in the police presence?
Yes.
So a pretty strong case for the government, right?
Well, the way I would look at it, Your Honor, when the police were testifying, the first officer said, we weren't sure why we were here. We thought that because they stipulated there was an unauthorized entry. So that's why they believed they were there.
So strong case for the Commonwealth or not?
Yes.
And the defense opening starts with, she cursed her out, and that's why we're here, right?
Yes.
So isn't that conceding the violation of the restraining order right there?
I don't believe the defense attorney ever conceded that, Your Honor, if that's what your question is.
It is. The defense attorney says the reason we're here is because she said to the victim, I'll call her the victim, you F you in curse words.
Correct, some choice words.
Right. And doesn't that conduct alone violate the restraining order that was in place?
If the jury believed that, yes. I mean, there's no way to get around it. I'm not going to circle around in circles.
Okay.
But the issue that I saw in is just a lot of these cases that deal with when the Commonwealth opens with accountability, or you were here today to punish the defendant, or those types of statements to the jury. What we have here is the jury almost forgets, you know, why we are here.
Not guilty on 2 out of the 3 charges?
Correct. But I don't think just because the defendant was found not guilty that the Commonwealth still, do we just look away because the jury did not find her guilty of 2 of the charges? When you read the case on those factors, the 2 of the charges, one of them was witness intimidation, and the other one, I believe, was disturbing the peace. And why that's important is, I mean, I didn't see any facts that would even support any of those facts. That's why I believe the jury found her guilty. This is way out there, but if the jury did convict her, I don't know how they would reach that assessment, but I know that's not here nor there. And what's important is, I know the Commonwealth pointed out in their brief, is the judge stated the jury instructions, what their purpose is. But in the beginning and throughout this case, this jury instruction is pretty much just one sentence. There's no force behind it. You know, opening and closing statements are not.
It's hard for us to discern force on a paper record.
Oh, correct. But
what we do know is that the jury were to presume that the jury followed the instructions, and the judge said that arguments and opening statements are not evidence.
Right, that's all he said. What I'm trying to say about force, like, he doesn't go into a lot of detail. For example, we get in front of the jury, there are a lot of jury instructions. I'm sure you guys remember doing trials, you have the function of the jury, the judge, counsel, all the elements of the charges beyond a reasonable doubt. The jury is just overwhelmed with all of these instructions, and they're sitting there, wow, look, this is a lot going on. And now, how much do you put into those jury instructions? That's just one thing I would like you to consider. And maybe think about the alternate side. Imagine the defendant, during his opening statement, said, "Ladies and gentlemen of the jury, today is about a case, nothing more than a statement. It's no physical violence. The Commonwealth wants to send Ms. Beatrice Sullivan-Rodriguez to jail for 2.5 years because of this word." I think we all agree that's completely inappropriate. But how is that so much different than the Commonwealth getting up there and saying, "Ladies and gentlemen of the jury, I want you to hold this woman who decided to come to trial, I want you to hold her accountable."
Aren't there cases where the prosecutors have made similar statements and they have not been reversed?
Yes, Your Honor. A lot of these cases tend to deal with the fact that the defense counsel did not object, similar to here. I believe the Commonwealth stated in their brief, forgive me if I say it incorrectly, Commonwealth versus Coyne, the 2022 case, which was a similar argument. The problem we have in this case is he says it at least 3 times in his open and a couple more times in his closing. At some point, I don't know if there is a number, sooner or later, I think the appeals court or the SJC is going to say, okay, you can only say it so many times before it does become a substantial miscarriage of justice.
But then again, going back to a point that I know you've already addressed, but if the question is how far or how close to that line is this case, where there are multiple charges on which the defendant was acquitted, doesn't that suggest that we're not at that line?
That's a fair question. I would state no. I wouldn't be ready to concede at this point. The reason why I say no, I don't know if there is a magic number. If it's some words are more, I guess, worse than others. But I would say no, just because, well, I realized 2 of the 3 counts she was found not guilty at. I don't think we should be able to say, well, I guess it wasn't too bad if the jury didn't find him not guilty. Why should we give, I guess, punish the defendant for the Commonwealth not proving parts of their case?
Could I change gears a little bit and ask you
Yes.
about the issue related to the mistrial argument that you have? What is it that you say that the judge was required to consider in deciding whether to grant a mistrial or not, and what did the judge not consider that should have been taken into account?
Thank you. Yes, I will move on. So the main issue in the mistrial issue is, I think she said it, I think it was 4 times, she was in jail, she was in jail, she was in jail. And
Their response to defense counsel's questions, correct?
yes, it wasn't like a direct answer to it. It was just kind of like a fleeting, it just came out of nowhere, basically.
And then the motion for mistrial was late, right?
It was late. He stated on the record at sidebar that he had an issue with hearing. I don't know, I couldn't find any case that says if that makes a difference. I don't know if that makes a difference. Maybe it does a little bit. But I would argue it was not too late. One of the cases where this was talked about, in the Commonwealth's briefs, for example, Commonwealth says Coito, C-O-U-T-U, 88 Mass Appellate Court, 686. It was a similar issue where the defendant objected very late. And in that case, the jury goes to deliberate, and then the defense counsel says, oh, Your Honor, I object. At that point, I think that is very late. The jury's already long
Well,
gone.
I mean,
But-
obviously, that's worse than what happened here. But still, I mean, the reason we have a contemporaneous objection and rule is that it empowers the trial judge to do something about it when it really matters, and not at some later point in time.
My counter-argument was going to be, and I realized it was late, whether it was prejudicial error or a substantial miscarriage of justice, I think it would meet both those burdens. And the reason is simple. That's how I would view it, is you have a victim testifying to almost spontaneous, to say, she was in jail. Why did you do that? You know, she was in jail, she was in jail. And right off the bat, the jury's thinking, geez, she's in jail for one reason only, because she was a bad person. She did something wrong.
So after she blurted it out the first time in response to the defense question, didn't the Commonwealth object?
I don't know if it was the first time or it was a subsequent time. I don't recall.
And the prosecutor told the judge that the witness had been instructed not to bring this up.
Yes. Okay, I thought it was the second time, but yes, it was the first time.
And then following the objection, the defense asked the question again.
Yes. But at some point, the jury sits there and they're thinking, why is she in jail? People don't go to jail just because. Did she go to jail because of a violent thing? Who knows why? It's just predisposed the jury to thinking the only reason she was in jail is because she did something wrong. And it's very difficult to fix that issue. I don't know if there is something that a judge could cure. Ladies and gentlemen of the jury, you heard that statement, please disregard that. But even though they're supposed to erase it, it's very difficult to erase in your mind, she was in jail. Was it because
Especially after a recess has gone by.
I'm sorry, Your Honor?
Especially after a recess.
I agree.
Was there a request for any curative instruction?
The trial attorney suggested to try and leave it alone, just to leave it alone.
But no, there was no.
Yes, that's a no. I think that it pushed the trial attorney in a very difficult position, is do I risk bringing attention to, again, ladies and gentlemen of the jury, disregard that she was in jail? Or do I leave it alone and hope that the jury says, oh, it wasn't a big deal, or hope that they weren't paying attention during that time? It's an impossible position, I think. And was that part of sound trial strategy? I would say so. If I was doing the jury trial, I don't know what I would do, but it's very difficult to sit there like, oh, she was in jail. Do I call attention to it again, or leave it alone and hope that nobody puts too much stock into it? And that's why I believe the judge abused his discretion. I'm sorry, this is going on. Abused his discretion and not granting the mistrial, just putting the defense attorney in an impossible position. And I believe the prosecutor also stated during that sidebar when he asked for mistrial, he said something along the lines of, Your Honor, I asked you not grant a mistrial because the victim's testimony is almost like waning, or she's not doing herself any favors. So when you stressed that it could have been a strong case, all of a sudden the tide starts to turn a little bit, because as you read the transcript, her testimony was, I guess, difficult for both parties, both for the prosecutor and for the defense attorney. So that's, for those, I hope I answered your question, Your Honor. And unless there are any other further.
Just a housekeeping matter. When you get a chance, can you take a look at Appellate Rule 16A8?
16.
And then take a peek at page 13 where you have your summary of the argument on your brief.
16A8. I'm sorry?
And then take a peek at page 13 of your brief where you have the summary. Thank you.
Will do. Thank you, Your Honor.
Mr. Joyce.
Good morning, Your Honors. May it please Excuse me. May it please the court, ADA William Joyce on behalf of the Commonwealth for this case. I'd just like to make a few points this morning. To start, I'll start with the obvious. Yes, the statements by the prosecutor asking the jury to hold the defendant accountable should not have been made. And I will inform the court that as a result of this case, our office has sent out an email to all ADAs informing them that they should not use this language in the future.
So that's great, but how does that help Ms. Sullivan-Rodriguez?
Well, the issue here is it was unobjected to, so we're at substantial risk, and we are conceding an error. So what this court looks at is, was there prejudice to the defendant, and did it materially influence the jury? The argument here is no, it didn't, for reasons that both Justice Hand and yourself, Justice Desmond, have pointed out. The Commonwealth's case was very strong. The offending statement was made in the presence of two officers as well as the victim. Defense counsel did more or less concede that the statement was made during trial. In fact, his strategy was to argue that the defendant was permitted to make this statement because she was in the midst of reporting a separate incident to the police.
So it's error, and you concede that, I get it.
We are conceding the error, yes.
And so one thing if it was in the opening, one thing if it was in the closing, but here they bookended it. You know, they asked to be held accountable not only in the opening, but also in the closing. At what point do you say enough?
I don't know that I can give an exact number. I think, and this is a common thread through all of the issues the defendant raises, is context is king, or context is key. Here, yes, the prosecutor did use it about 5 times, I believe 3 in the opening, 2 in the closing. But the jury was instructed both before opening statements that they are not to consider the arguments by attorneys, that they are only to consider the evidence. After the defendant's closing, they were then instructed not to take their personal feelings or consider potential punishments the defendant may face into consideration when making their deliberations. And again, they were given the standard instructions after closing. So based upon that, and also the fact that the jury did acquit the defendant of 2 of the 3 charges. She was acquitted of, the 3 charges were obviously violation of the order, disorderly conduct, and witness intimidation. They acquitted her on the disorderly and the intimidation charge, and found her guilty on the very obvious, very strong charge. Based upon that, I'd say there is no prejudice to the defendant, nor did the statements alter the jury's verdict or influence it in any way. If I may shift to the other issue that was raised regarding the motion for a mistrial. As this court has pointed out and the Commonwealth has pointed out, the objection was not timely. It was about 10 or so minutes after the offending statements. And to kind of set out the sequence of events, the statements were made by the witness the first time, prosecutor objects, the court then calls a sidebar, the prosecutor represents to the court, I instructed her not to talk about this, I made it very clear to her. Unfortunately, the transcript is unclear what the court's response was, he appeared to be garbled. The court then asks the defense counsel, is there anything you want to put on the record? And he says no. Sidebar concludes, the witness does then make the same offending statement again. Testimony concludes, because this was COVID, the courtroom was cleared for cleaning, approximately 10 or so minutes pass, and when they come back from recess, then the defense counsel asks for a mistrial.
So you say it's substantial risk, not
Yes.
prejudicial error. Okay.
The issue was waived, and we're at substantial risk. And then there are a number of factors that weigh against the defendant there. First off, it's a strategic choice. When the judge said, if I'm not inclined to give you a mistrial, do you want a curative? And the defense counsel makes the choice, no, I'd rather you just leave it be. Didn't ask for anything like a motion to strike, just said, leave it be. That's a clear-cut strategic choice. My apologies. I had one more point and I just can't remember it. No, apparently I was wrong. I did not have another point. Unless this panel has any other questions,
Seeing none, thank you. Thank you both.
the Commonwealth will rest on its brief.
The next case is 21P 1064 Commonwealth versus Rodriguez. Ms. James.
Good morning, Your Honor. May it please the court.
Okay, proceed. Go ahead.
Jose Rodriguez was deprived of his confrontation rights in two significant ways. When the judge denied completely,
Excuse me, can you bring that microphone closer to you if you can? Yeah.
when the court denied cross-examination of Ms. Torres regarding her involvement in gang activity and that of her son, Jeremiah.
Was there any evidence that the defendant was involved in gang activity?
Not presented at trial, no. Jeremiah was a person who was Ms. Torres' son who was present at the time of the altercation, and Ms. Torres herself was the store clerk. What would that evidence, how could that have helped Mr. Rodriguez? It would have helped him in that it would collaborate. It would have collaborated his self-defense, defense that he was in imminent fear of serious bodily harm or death from people who were members of gang.
Was there any evidence that he knew that they were members of gangs?
No, not
Or
presented
potentially
at trial.
associated- Or potentially associated. We're only talking about a trial, or potentially associated with gangs.
There was no evidence at trial that he was involved in any sort of activity, gang activity himself.
Was there any evidence that he was aware or had some idea that maybe Mr. Medina or Ms. Torres were involved in gang activity?
Well, it was public knowledge that they were involved in gang activity, because what was presented at trial by defense counsel were two press releases.
They were from 9 years before, though.
One was true.
Yes, they were 9 years old at trial.
Not both.
Okay.
The second one, where Jeremiah was pleading guilty for having been an enforcer of gang activities, et cetera, in New Bedford, that was in 2021.
How do we know this is common knowledge, though? I mean, I don't read FBI press releases. Who really does?
Well, it's on the website of the FBI and the website of the U.S. Attorney's Office. So people who are, excuse me, interested in that sort of information would read it.
How would you know that was his son?
She said it was her son. Defense counsel asked her, and she admitted Jeremiah was her son. But
Ms. Torres' son?
I thought it was
Excuse
Mr.
me?
Medina's.
I thought it was Mr. Medina's son.
it was Ms. Torres' son, who was the clerk in the store where it happened.
Okay.
And his last name was Medina, and so was not to interject this, but the other person involved in the altercation's name was also Medina. So that, the denial of the cross-examination was also, some similar information would have come from Detective Bryant regarding what kind of activity was happening at that store itself, where Jeremiah was present outside and where Mr. Medina was engaged in this fight with Mr. Rodriguez. The detective was allowed to testify that they were called, police was called to that store often, but the cross-examination was stopped by the court when counsel tried to ask about the nature of the activities and why they had been called to the store. So for those two reasons, both of those testimony, both from Detective Bryant and from Ms. Torres, would have corroborated Mr. Rodriguez's self-defense defense, that these people were engaged in gang activities and therefore were dangerous. This was not just any gang, it was the Latin Kings. It also would have allowed the jury to judge Ms. Torres's possible biases.
But we're reviewing for an abuse of discretion here, correct?
Excuse me?
We're reviewing for an abuse of discretion.
Yes?
So we have to conclude, or you have to establish, that what the judge did here was outside the range of reasonable alternatives. And with an attenuated claims from old press releases and without knowledge by the defendant that the victim had any such affiliation, why did this fall outside the range?
It falls outside the range because this, the case law basically speaks of even if the evidence, the possibility of this type of bias presented to the jury, even if the possibility is remote, the judge should not completely close off that avenue. He could have limited it, but not completely banned it, and that's what happened here. And the case I'm referring to is Commonwealth versus Tambui. Those are the reasons why I think Mr. Rodriguez's right to confrontation were denied. But coupled with that, at one point, the judge had ruled that Rodriguez's prior record would be admissible, and it was prior record of assault, and that, in addition to the denial of cross-examination, really chilled Mr. Rodriguez's decision to take the stand. Any testimony about gang activity coming from him at that point in the trial would have been looked as a recent fabrication and would not have had the type of evidentiary value had it come from Ms. Torres and from Mr. Rodriguez. The second point in my brief, Your Honor, has to do with jury instructions. I believe that the model jury instructions and the way, perhaps this is not the best authority, but the way I have heard it in the course of trials is that the judge would generally instruct that the jury may infer or they may find guilt, but to say, as the judge said here, that if the Commonwealth had proved this, then you can find guilt on the lesser included. Then they proved the lesser included.
Isn't that true?
Excuse me?
Isn't that true? If the Commonwealth had proven beyond a reasonable doubt all of the elements except for X, and there were a lesser included that was proven by those elements. Isn't that a correct instruction?
Well, it is correct, but when the way it was delivered 3 times in succession to the jury, and
Well, there were 3 different lesser included.
yes, but that was repeated. Yes, it was.
He's used the same, he couched it in the same language. If the Commonwealth has already proven these elements, then you can find, and not say weapon or not serious bodily injury, then you can conclude that he's guilty of the lesser included. But that's all premised on the idea that the Commonwealth has, you jurors have to decide if they have proven these elements. And if you so decide, then he's guilty of a lesser included. I fail to see, short of some semantic rearrangement of the phrases, that the jury could misunderstand this.
I'm not going to pursue this line of argument because you obviously have.
No, I'm asking you to set me straight. What am I missing?
Well, what I think is missing is is the direction. It's almost telling the jury that they should find guilt. They should find that he's guilty by saying, if they didn't do this, if they did this, or they didn't prove that there was a knife, then they proved. That's where I found issue with it. The next point I made in my brief, Your Honors, were regarding the missing witness instructions. I thought that the only civilian witness who testified at trial was Ms. Torres. Mr. Medina never showed up. And I don't think the Commonwealth did. They did try, but I don't think their efforts were sufficient in getting Mr. Medina to court. They could have called the Registry of Motor Vehicle, for example, the local post office or probation office to get an address for him. There was just a summons left. The detective who apparently helped the prosecutor locate, didn't testify as to what his or her efforts were in trying to locate Mr. Medina.
The Commonwealth says that Mr. Medina was hostile to the government and their prosecution of this case. Doesn't that sort of end it right there? That's one of the things you have to show the witness is not hostile. He didn't want to participate in this. You also say in your brief that, in sort of conclusory fashion, that the Commonwealth had superior knowledge as to Mr. Medina's whereabouts, but where do we find that in the record?
We find that basically because they're police, and that they have greater means of finding someone than I would.
Greater means versus superior knowledge. I don't know if those are synonymous.
Oh.
I mean, then that would be in every single case when a defense wanted a missing witness instruction. They'd say, well, that element is checked because they have police.
Right. And perhaps it should be checked that way.
I see.
As far as superior knowledge. The last point I want to make is regarding the closing argument. Some of the remarks were untrue, just plain untrue. There was never a knife recovered anywhere. So, and Mr. Rodriguez was arrested at the scene. There was no audio, and yet the prosecutor attributed certain comments to Mr. Rodriguez. Many of the questions pointed to Mr. Rodriguez's failure to testify at trial, and by asking why didn't he leave, why is he pulling a knife before, when, or...
So he's not doing this
when he
as,
just
as, I'm sorry, as Judge Cosgrove said, the prosecutor isn't doing this in a vacuum. He's talking about what he sees on the video. And he's saying, like, if he was so concerned about his safety, why didn't he just get in his car and go away, as opposed to getting into an altercation? I mean, that's, how is that a comment on the defendant's failure to testify?
In fact, he did get away. He left and returned
After the
with
altercation.
police. Right, after, yes. And, you know, speculating as to what the people who were around were, why were they weren't doing anything wrong. And it seemed like the jurors would have been waiting for Mr. Rodriguez to give answers to those. He had not testified at trial, and the cross-examination of the witness, I would have corroborated anything he had to say was banned entirely. Thank you.
Thank you. Mr. Kennedy.
Thank you. Good morning. May it please the court, Nathaniel Kennedy for the Commonwealth, asking me to affirm the defendant's conviction. As two housekeeping measures, I do believe that counsel unintentionally misspoke. Ms. Torres was not the son of Jeremiah, or the parent of Jeremiah Medina. The allegation is that the victim was the father of Mr. Medina, so I just wanted to clarify that. That's on page 26 of volume 5 of the, page 25 of volume 5 of the transcript. And secondly, I wanted to apologize. In my brief, I refer to the press release as a police report. It's a press release that was provided to the court to substantiate any claim that the victim or the witness had any connection to the Latin Kings gang. So I'll start there. Counsel spent some time discussing the restriction on cross-examination and how Ms. Torres was not, or it was not permitted to inquire of Ms. Torres about her potential gang ties. As I pointed out in my brief, the factual basis was just not there for there to be any inquiry into this potential gang tie. The press release, which was provided in defendant's appendix, states that 46 individuals, many of whom are alleged to be associates of the Latin Kings street gang, are charged with narcotics offenses here today. Ms. Torres was one of the 46 individuals. There's no police report, there's no board of probation record, no conviction, no information contained in this press release that shows how any associations are made between Ms. Torres and the Latin Kings gang. And the case that counsel and trial counsel heavily relied on was Commonwealth versus Murray, which was a very different case. In Murray, there was a substantial record of how these gang members, this group, were associated, what methods they used to evade police, how they're encouraged to lie for each other, to lie to the police. None of that is present here. There's no record of how any associations in this alleged Latin King tie, how they are structured, how they are encouraged to lie, how there's some motivation to not cooperate with the police. And I think it is a bit of a far reach to say that there's just this blanket assertion that if there's an association or even some tie to a gang, that's just a blanket, this person's a liar, this person's motivated to lie for each other. I think that's going way too far in allowing.
Was she trying to draw a link between the gang and lying, or the gang and their dangerousness, and hence his self-defense?
Both. Well, there's, I think, a twofold issue, whether they're, one, as you pointed out, there was no evidence that the victim or the defendant knew of the victim's potential association with the Latin Kings at the time of the event. So that kind of undermines any of the self-defense argument. And then also, it appears that there was an effort to cross-examine Ms. Torres as her motivation to lie and to impeach her. And that's just not here. The cases require, yes, there's a broad permissions to cross-examine, when particularly there's a motive to lie. But there is still within the judge's discretion, the ability to limit cross-examination on collateral issues or issues that are so remote that they're really just not relevant at the trial, and that's what we have here. I list in my brief a series of cases relying on Commonwealth v. Seeley, Tambui, and Jones. Jones is a 2017 case that talks about the limit on tenuous facts is within the discretion of a trial judge, and that no inferences of bias could be made from the proffer at issue there, and I think that's what we have here today. Moving on, unless there's any questions on that issue, to the lesser included instruction, I think the panel all recognize that this is an accurate instruction that Judge Cosgrove gave to the jury. It's an if-then, and where we have a series of lesser included offenses, he was giving guidance to the jury that if they have X elements, but not Y elements, then what's left is this. And the jury, finding a lesser included offense, clearly followed Judge Cosgrove's instructions. Just to bolster the point that the jury was aware of what their responsibilities were, Judge Cosgrove made it clear not to misinterpret any instructions as his suggestion of opinion, that he's not making any opinion as to the facts of this case. So where we're reviewing whether there's a substantial risk, there is no error, first and foremost. The instruction was proper, and the jury is presumed to have followed that instruction. Moving on to the missing witness issue, the Commonwealth provided to the court substantial justification for why this witness was unavailable. As Your Honor pointed out, Justice Meade, he was hostile the entire pendency of this case. To get him to the grand jury, there was great efforts made. He did come after a series of steps that the Commonwealth had to go through there. But the defendant acknowledged in a hearing that's contained in transcript, I believe it's the first transcript, that the victim doesn't want to be here, the victim doesn't want to show, he's not involved in this case, he's hostile to the government. They're conceding, they know he's hostile to the government. But nonetheless, the government still, we sent out a police officer to try to find him, serve him at his last known address, checked with the jails, and did not request a capias because no in-hand service had been conducted. So we wouldn't have been able to request that he be brought to court forcefully as Ms. Torres was. So there was no abuse of discretion for failing to give the missing witness instruction, which is a powerful instruction as the court recognized and is only to be given in limited circumstances. Finally, pointing to the closing argument issue, the Commonwealth, in an effort to rebut a self-defense claim, properly put forward to the jury rhetorical questions that were meant to demonstrate the implausibility of this claim.
In the video, can you see him flick the knife?
I am uncomfortable characterizing what I see in the video. I think the jury didn't find a knife, so they didn't find that it was a dangerous weapon. But that was the Commonwealth's theory, and the injury sustained by the victim was a laceration. And
I understand, but can you see him draw the knife from his pocket and flick it?
You see him make motion that is consistent with pulling an object, but there is no clear image of a knife. Again, that's me characterizing the video. But the Commonwealth's theory, again, based on the injury to the victim, a laceration of his ear, which was a substantial laceration, likely wasn't done by a hand. And the only other object that would be able to do that was a knife. There is a motion consistent with that. So I don't believe that it's somehow not in evidence or a reasonable inference to be drawn from the video or the evidence that was in play. So the Commonwealth was asking for the jury to draw reasonable inferences from what they see in the video, which ultimately they're the determiners of fact and are viewing the video for what they believe, then finding that it was just an assault and battery, no dangerous weapon was, there was no guilty verdict on the dangerous weapon component. So first and foremost, there was just rhetorical questions which were proper, and then there was another subsequent question that the defendant nearly chopped the victim's ear off. What we have here is a 5-centimeter laceration. A photo was included. It's also attached to, I believe, the defendant, and I included in our record appendix. There's a large portion of the victim's ear missing. The medical records, which were also included, indicate that there is an injury causing a deformity of a 5-centimeter laceration of the ear. All consistent, I think, with being nearly chopped off. I think that is a fair characterization of the injury to the victim. Panel has no further questions. I'll rest on my brief.
Seeing none. Thank you. Thank you both. Turned it up. It's freezing. It's freezing in here. It's blowing cold air. Yeah, I think it is, yeah. The next case is 22P94, Commonwealth versus Kenney. Mr. Shawla.
Thank you, Justice Meade. Members of the panel, may it please the court. My name is Stephen Shawla, and I represent the appellant. The two issues before the court in this particular instance is whether or not the judge erred when he failed to give a voir dire to a sleeping juror. Instead, he had all of the jury panel stand up and do stretching exercises. The second issue is whether or not the judge erred when he failed to give a colloquy and accept a written statement from the defendant in a bifurcated trial. This was an OUI 5th out of Attleboro District Court. The first issue, again, regarding the sleeping juror, it was the judge himself who made the observation while he was giving the closing instructions to the jury. Basically, and this of course is the most important part, usually in a jury when the judge is being, when the jury is being charged with the law, specifically that closing arguments and opening statements are not evidence. It's at that point where the judge noticed that a juror was nodding off. He called the attorneys to the sidebar, and he basically told them, I'm going to have the jurors stand and stretch. Basically, the law is very clear on this. In Commonwealth versus McGee, if information is brought to the judge's attention that a juror is either sleeping or inattentive, he should inquire insofar as whether or not it is reliable information.
It says the judge is supposed to intervene, and how the judge intervenes is a matter of discretion.
That's correct, Your Honor. I believe
It doesn't say he has to conduct a voir dire.
No, but basically what he basically was explaining to all of the jurors was that he was going to have stretching exercise. I think where the abuse of discretion comes in, Justice
calling it a
Meade.
stretching exercise, and I get it.
I'm
But
sorry?
I said you keep calling it a stretching exercise, and I get it. But that's not what happened here. I mean, he didn't have him do a stretching exercise. He noticed a juror who was nodding off. He brought it to the attention of the counsel and had a sidebar. Nobody asked for anything specific to be done. He informed them that I'm going to have him step up and stand up and move around a little bit. And that's essentially what he did. So to say it was a stretching exercise, don't you think that's a stretch?
Well, yes, Justice Desmond, to a certain extent. I think where it comes in, though, is the fact that it was during a critical stage of the trial whereby he was giving the instructions to the jury insofar as what the law is, and he happened to notice this particular juror nodding off during the point where he was explaining that opening statements and closing arguments are not evidence.
But he also told them at the beginning of trial that opening statements and closing arguments are not evidence.
That's true, Justice Meade.
There's no indication that anyone was nodding off at the beginning of the trial, as they might do during an appellate argument.
There is also a reason why why charging the jury is also done at the end of the trial as well. And, you know, great if they happen to remember what was said at the beginning of the trial. In fact, I believe Commonwealth argues in their brief, speaking about, again, I shall use the word stretching exercise, standing up, whatever the case may be, that I believe it was in the Dancy case that the judge did the same thing. But it was at the beginning of the trial when he noticed two jurors nodding off. In this particular case, it was at the end of the trial when, again, the most important part of, and I don't mean to keep repeating myself, closing arguments and opening statements are not evidence.
I guess the problem, I'm sorry, go ahead. No, I was going to say, and Justice Desmond touched on this already, that he says we're going to have them get up and stretch, and defense counsel and the prosecutor are on board, and no one asked for anything else. So how is it an abuse of discretion, or you say it's arbitrary when everyone agreed to it.
Well, if I may cite Commonwealth versus Dryas, the case was still reversed where the defendant nor the prosecutor objected when there was no voir dire. And the court still reversed in that case because I believe they called it was structural error. So whether or not
Which court said that?
whether or not the defendant or the prosecutor.
No, the case you cited, what was the case?
Commonwealth versus Dyus, D-Y-O-U-S, 79 Mass App, Court 508,
Thank you.
2011 case.
But that case distinguished between momentary nodding off and sleeping as a more general matter, correct? Isn't that what Dias was talking about?
That's correct, Justice here, but I looked at the definition of nodding, dozing, and under Webster's dictionary, it equals sleeping. So not a deep sleep, but bottom line is you're not being attentive if you're nodding or if you're dozing.
Understood, but if you're looking at Dias, Dias appreciated the difference between those two concepts, that they are not they may be part of a continuum, but they are not necessarily interchangeable.
And isn't that the same with some of the other cases you cite, where there's multiple jurors and one of them was sleeping the whole day or a good part of it, versus the judge happened to notice somebody dozing off in a closing, not during the evidentiary portion of the trial, and brings it to the attention to the lawyers?
There is a whole litany of cases on that, Justice Desmond. I think where this differs is the judge had an opportunity after the exercises to cure this by very simply repeating what the judge himself observed, and said, okay, I'm just going to repeat it without picking out the juror specifically, by just basically saying, and again, closing arguments, opening statements are not evidence, because it was the judge. Again, case law says if it's brought to the judge's attention that there may be an inattentive juror or a sleeping juror, then the judge has to determine if it's reliable information. Here it was the judge himself who observed the juror nodding off. So obviously, per se, the information was reliable. So again, he could have cured that. By all means, everybody gets a little tired, obviously, during trials. Stand up, stretch, do whatever. And after that, where the cure, I think, could have come in was where the judge could have just very briefly repeated himself of what he knew, because he's the one who saw the juror nodding at a certain point. What he knew, he could have just repeated it.
Out of curiosity, is there something in the closing argument that your client would argue the jury took as fact or as evidence that it shouldn't have?
Not to my knowledge, Justice, no. The other issue, again, was whereby the judge failed to do a colloquy and get a written jury waiver in the bifurcated case.
Commonwealth concedes error, right?
Commonwealth concedes error on that.
So what would you have us do?
I'm sorry, Judge?
So what would you have us do? Send it back?
Yes, that's basically, I believe, what the case law says, to reverse and remand on that case.
So could I just ask a clarification on that? Are you asking that the convictions on the subsequent offense only be vacated and the matter be remanded with respect to that aspect of the trial, or are you making a more broad request?
Well, basically, if that was to happen, Your Honor, I believe it would have to go back for the entire trial, even on the underlying case.
Why? That was a jury verdict. Why would that have to go back, the OUI?
Well, it would have to be, obviously, a second jury that would have to come in just on that matter.
On the subsequent offense portion?
On the subsequent offense, and I believe, unless I'm mistaken, the defendant has a right at the same jury that convicted him on the underlying matter for the trial on the subsequent matter.
After trial on the OUI, did the judge inquire as to whether that jury should be retained?
I don't believe I saw that in the transcripts. I don't believe I saw that. Again, I believe this was a side agreement, as my brief states, between the district attorney and the defense counsel. They drafted up between them a stipulation. Even the judge queried it. He said, usually we get a green sheet on this, but notwithstanding, the judge went along with the stipulation, and the only questions he had of the defendant was, did anybody force you to enter into this?
It was
Answer,
error.
no.
It was error.
I'm sorry?
I think it was error, right?
Yes.
Okay, so we're past that. So now the question is, what do we do?
Well, considering the fact that we have two, and again, I'm arguing two errors here. Error on the fact that we had no
Well, yeah,
idea.
let's say, Mr. Shala, we don't agree with you on issue 1, and so we're going to affirm the jury verdict in this case, just hypothetically.
Mm-hmm.
And you said in your brief, and now I'm confused, that it's not appropriate to remand on the subsequent offense, but now you're telling us it is appropriate to remand.
Well, obviously, we would want it not to be remanded and just overturned. And again, where we would be going with this is, in all honesty, case law does suggest a remand on this.
Yes, I mean, it's continuing jeopardy on the subsequent offense.
That's what, and I looked into this too, what are the instances normally where something is just totally reversed, and it's usually double jeopardy, it's usually where there's insufficiency of evidence,
Or
cases
misconduct.
along those lines.
Right.
But this particular case here, yes, I would be arguing that it be reversed and not remanded in this particular
You
instance.
said the defendant has the right to the same jury. Do you have some authority for that? I'm not familiar with that.
I don't have the authority on it, Your Honor, but I do remember reading it in one of the cases, but I don't have the case cited, but that's all I can say on it, whereas he had a choice of either the same jury or an alternate jury, but because he was never given that chance, it becomes a
Yeah,
moot
but
question.
I'm assuming that didn't take place after a remand.
I don't know that answer.
So when he's convicted, you have a right to a jury trial on the subsequent offense.
Correct.
And you can have the same jury or another jury.
Correct.
Right.
Exactly. But he was never given that opportunity because of the fact of he entering into this quote-unquote stipulation. I have nothing further unless the panel has any further questions.
No. Thank you.
Thank you.
Mr. Kidd.
Good morning, Your Honors. May it please the Court, my name's Rob Kidd for Bristol County DA's office. I represent the Commonwealth here. The question before the Court is whether the trial judge here abused his substantial discretion in choosing to handle this juror in the way that he did. And substantial discretion, as we know, means was his decision within the reasonable range of alternatives, not whether what he should have done or what would have been the best practice, was it within a range of alternatives. What this judge decided to do in the moment, after he personally viewed these jurors sleeping, this juror nodding off, as he said, he called, as the Court pointed out, he called the lawyers to sidebar. He told them he observed this juror just a couple of times, quote unquote, nodding off, and he told them, what I'm going to do is take a break and have them stretch. And that is what he did. Both counsel agreed with the plan. One of them said, absolutely, Your Honor. I forget what the other response was. The question is whether this judge in the trenches, so to speak, in the trial did, abused his range of discretion. We might say that, again, the best practice might be in every single case for every judge to have a voir dire, but this judge wasn't relying on other witnesses. He wasn't relying on what other people told him. He was relying on what he saw with his own eyes. In that sense, his observations are they're personal observations. So I think in that sense, he deserves to be given the discretion that we are supposed to be giving him, because he was there, he saw the juror, he saw the juror, quote, nodding off a couple of times. He made a determination himself after viewing that it was not a big enough deal, quote unquote, to go into an entire voir dire of the juror. He satisfied himself with the stretching exercise or the moving exercise or whatever it's called, that he had done followed the law, and that this juror was able to continue as a juror. I've cited a lot of cases. There are 38 cases on sleeping jurors. I don't know if that's a comment on the system, but that's an exhaustive list that as far as I can tell, I looked into it. And as I said, that list that I cited are all cases involving jurors sleeping through the testimony, jurors sleeping through cross-examinations, jurors sleeping through closing arguments, and some of them are witnesses by 2 or 3 people, and the judge is not taking action. He's not doing a voir dire. And as Commonwealth versus Dancy says, was the case that I cited. Dancy says that in some situations, if a juror is beginning to nod off, it might be appropriate to have the judge stop the jury, stop the trial, and have them do some stretching. And I suggest that this is that case. I haven't found a case like this where where there's an exercise of discretion in very similar circumstances as Dancy, but here it is. I suggest this falls well within the dicta in Dancy, and I would ask the court to uphold the verdict on that. On the other issue, I've cited case law in my brief on page 18. That's Commonwealth versus Zuzik. In that case, 1998 case, the court, in the case of a jury verdict on an OUI case where there was a defective plea colloquy or no plea colloquy, they sent the case back to the trial judge. They vacated the conviction on the subsequent offense, sent it back to the trial judge in order to do it right pursuant to, I think it's Chapter 278, Section 11A. And the judge presumably went through the plea colloquy with the defendant, gave him an opportunity to have his subsequent offense trial if he wanted it with the jury, that's how it's supposed to be handled. The defendant cites a case in his reply brief. I just want to let the court know, Commonwealth versus Dussault, D-U-S-S-A-U-L-T, 2008 case, and he says it's similar to this, he says that they did not, they vacated the conviction, but actually if you read Dussault, at the end of the case, it says that they sent it back, they did remand it back to the trial court for further proceedings, and it doesn't say what the proceedings were, but I would venture to guess that they were consistent with the case of Zuzik. I really don't have much to add. I'd be happy to answer any questions from the court.
Seeing none, thank you. Thank you both.
Thank you.
What's the next case? Oh, you got the order?
Yeah. The next case is 22P383 Pine Tree Village Residents and Associates versus ALMEIDA. Mr. Bond.
Morning, members of the panel. May it please the court. Just as an initial matter, I just want to note that if any of the arguments in my brief are not covered here today, I'm not planning on waiving them.
They're not waived.
To sort of streamline this appeal requires, from my perspective, a statutory interpretation of the Acts of 2020, Chapter 65, which appears to preempt this issue. The SJC orders to which I refer regarding court operations under exigent circumstances created by COVID, I think are consistent with 65 for purposes of dealing with the issues we have here. I submit that Chapter 65, Sections 3C and 6 toll all the deadlines in the agreement for judgment in the housing court below. 3C commands that a deadline or a time period for action by a party to a non-essential residential eviction, whether the deadline was established before or after the effective date, which was April 20, 2020, shall be tolled, and it's a shall be tolled. Section 6 sets the toll as 120 days after the effective date of the act and elaborates that any deadline or time period tolled under 3C shall begin to run upon expiration. What that language does, and it's significant here, is it's basically you stop the time and you pick it up from where it left off. So if there was 10 days left at the time of the toll, you take those 10 days, bring it to the other end of the toll, and continue on. I like to think of it sort of like the first down markers. You don't move one first down marker, you move both first down markers in order to deal with the tolling.
So
here,
if it's tolled, it pushes you into August of 21, right?
It pushes me into August of 2021. It also...
And the motion was filed in June of 21.
It was, Your Honor.
So that takes care of that.
That to me is the objective criteria that's necessary to determine that I think it was clearly erroneous below. If there are no further questions on that, I can move on. All right. As to the second step, oddly enough, there was no opportunity to be heard at the initial motion. So
was that the TRO or?
Well, that was the TRO, which then got scratched out at a quote unquote hearing in the lobby, to which I wasn't present. that then became a PI, which I assume was a permanent injunction, since it dismissed, saying that the tenancy was reinstated and had to be reinstated by May, which I argue should have been
Would have
August.
to-
I'm sorry, permanent injunction or preliminary injunction?
Well, it said PI, but since it threw my case out and there was no chance of coming back and no hearing was set, nothing was, if I hadn't moved to reconsider, I would have never gotten before the judge. Nothing would have happened.
It
Except
has,
for,
it has to be a PI or we don't have jurisdiction.
it is a PI then. It's a PI then. I'll stretch a little bit here to wake myself up. But the point, I guess, that I'm making here is what's classic in the housing court, since it moves very quickly, and you've got people that are sitting there looking to save themselves from eviction, is you get a call from the court that says we've got a TRO here, which typically just lasts 10 days, and then you go back to the eviction. They call you up and say, do you object? I say, of course I object. Judge does or doesn't grant the TRO. Here, he, without a hearing, without telling me it was a PI that was being considered, a PI is granted. And now I'm sitting there with no opportunity to be heard. No papers were served on me. I believe your honors asked for what was the other side of that statement of material facts, which I can't find. I got that after the hearings and everything were done. I begged the court for it. I got it, and I got it one-sided. I'm not sure that it's relevant when you start dealing with the objective quantifiable criteria of the tolling. But in this circumstance, there's no service, there's no notice. The court's telling me a TRO and it turns into a PI.
Could I just step back and ask one question?
Ask
Not
as
to
many
throw
as
you
you
off
like.
track, but there was a hearing before Judge Salvidio, but there was no hearing with respect to the TRO to PI in front of Judge Michaud. Is that
Correct. And the
correct?
Salvidio, I apologize, Judge Salvidio, the one before Her Honor, came before, it went Judge Salvidio for the request for the execution.
And
They
did
then
she
came in
grant-
for a TRO.
Sorry, go ahead and finish.
So
your
the
answer.
TRO, they came in for a TRO on the execution. We then served the 48-hour notice. They came into, I'm sorry, the first TRO was denied by Judge Michaud.
Right.
Then you have the service of the 48-hour notice in September, and then you have, I think it's September 8th or September 12th, you've got the next TRO that comes in by the tenants that goes before Judge Michaud. That's where I get the phone call. That's where he then decides to turn it into a PI.
So with respect to the hearing in front of Judge Salvidio, if I understand the docket correctly, it was a motion to enforce and a motion for issuance of a new execution, correct?
Yes, and I apologize for being semantic. They never issued the first execution that they were supposed to under the agreement
Okay.
because COVID happened.
Okay.
And Rule 65 said you couldn't issue them.
Okay. But was the motion, the execution was to be issued under Judge Salvidio's order?
Yes.
Was the motion, and this may be just a technical question, but was the motion to enforce also explicitly allowed?
For the execution and for us to go in and evict, essentially. She had looked at the photographs, seen that there had been no compliance with the order or the one-year probationary period, looked at the photographs and said, fine, I will issue the execution, go serve. Go do your 48-hour notice.
So implicit was the allowance of the of the motion to enforce,
Absolutely, Your Honor, absolutely.
rather than explicit, is what I
Yes,
guess I'm
they
asking.
sort of piggyback together.
There was no separate endorsement that said?
Correct.
Okay.
Correct, Your Honor.
Dead horse beaten. Thank you very much.
And the last piece of this, if necessary, is that if you accept the lower court's ruling, and what they did, it rewrites the AFJ, the Agreement for Judgment. And an Agreement for Judgment in the Housing Court 1 expressly says on it, this is a court-ordered injunction. And Thibbets and other cases say that in order to undo an AFJ, to change the agreement in the AFJ, you need a new agreement to the parties. These things are somewhat sacrosanct. And I can understand why. It's pushing settlements, trying to get some agreements, and then giving them some heft so that they're not easily torn apart. Well, here it said explicitly, if tenant complies, then it shall be reinstated. And the if was never met. And by doing what Judge Michaud did was he basically said, if you, Mr. Bond, don't come in by May 2nd, which, by the way, was a Sunday. We knew that when we wrote the agreement. We did it for a Monday because that's when the housing court is open. So he would have had me deadlined on a Sunday. But if you don't come in and you don't make a motion, we're going to assume they complied and we're going to reinstate.
For how long is the judgment for possession valid?
90 days. I'm sorry, pardon me. The judgment for possession, I think it's just, it operates like a normal judgment. It's the execution which is key, and that's operational for 90 days. The other thing here is this is a manufactured housing community, and there's some other aspects that come into that in terms of they don't lose their home because they get 120 days to sell it, because they own the house, we lease out the land. So there's some slight differences there. But yes, the execution is good for 90 days, and it was still good at the time that it was served.
But there's no, at least, are you representing that the judgment didn't, for any reason, expire before the proceedings at any time relevant to this action?
Correct. It had not expired. So at the end of the day, I think the quantifiable manner in which this appeal can be viewed is the tolling issue, without needing to get into the other issues. I think that if it is a deadline like he called it, it's tolled under 65. If it is a deadline like he called it, it's tolled under the second and third updated orders of the SJC. If it's not a deadline, then I'm not sure why I would have had to have done something. We're a deadline, and this is the last place I land. If it's not a deadline, and this court looks at it and says, yeah, but Mr. Bond, how was the court, as the judge said, how was the court supposed to know? Well, we have in the law something that says where a court or an agreement or something does not provide a specific time for action, we interpret in a reasonable time. Within 30 days or 40 days of that May date, I served them with a notice, with a 48-hour notice. If you think about it, there is no prejudice to them. They get to stay in longer. You're also dealing with a time period where there was COVID. And putting people on the street, I mean, my client and I are not known for being really nasty people when it comes to the housing court, but particularly when you're dealing with COVID, that was not a prejudice to them. It kept them in their home during that period. So I don't think the amount of time, if it wasn't a deadline and you had to interpret a reasonable time within which to serve, I don't think serving in June on a May date that he claims expired would have been an unreasonable time frame. If there are no more questions, I thank you for your time.
Thank you. Thank you very much.
Honors.
We'll take that under advisement. We're going to take a short recess.
in session, please be seated.
The next case is 22P685, WEINSHEL versus SOUTHCOAST Physicians Group. Ms. Carboni.
May it please the court, good morning. My name is Felicia Carboni, and I represent the appellant Alan WEINSHEL. The issue before the court today is whether the trial court erred in granting summary judgment to appellee SPG SOUTHCOAST Physicians Group on the principles of successor liability. It's the gravamen of appellant's position today that no single factor is necessary to establish a de facto merger under the principles of successor liability, and that the record evidence established on summary judgment that 3 of those elements were strongly met and should have been in favor of the appellant, Alan WEINSHEL. Those factors include continuation of enterprise, that the seller ceases ordinary operations, liquidates, dissolves as soon as practically possible, and that the buyer-purchaser assumes obligations of the seller necessary for the continued operation of normal business operations. Here, the business operation was the provision of medical services. The corporation did cease all business operations after the asset sale. Those were assumed by the successor. The assets were liquidated, and the assets...
So did they wrap up right after, or did they remain open for maybe 2 years or some period of time with one of the ladies who became an employee of the new company still holding her position for MBMA?
Yes, Justice Desmond, I can address that. The record evidence establishes that, in fact, they voted for the authorization of dissolution of New Bedford Medical Associates within about a month of the asset purchase agreement being executed, and that was in 2014. And that occurred about 15 to 20 days before the amendment to the asset purchase was signed on June 1st of 2014. If the court pays close attention to the asset purchase agreement, the APA, the actual asset purchase agreement in section 2.9 describes that the assets that they're acquiring, with the exception of those that are excluded, are all of those that are necessary for the actual business of New Bedford Medical Associates to operate. So in effect, there was no services that were being provided because pursuant to the asset purchase agreement, the successor corporation contracted to take the non-physician employees to offer them essentially employment dating back to when they started at the New Bedford Medical Associates location, as well as assuming their healthcare obligations. It also, the agreement...
Could you help me out? Maybe I've got it wrong, but I thought the APA excluded the agreements at issue here with the plaintiff.
Yes, Justice Meade. So what I'm referencing right now is...
I'm sorry, yes, they did?
Well, so there's 2 different provisions. There's acquired assets, and then there's acquired liabilities. So in answering Justice Desmond's question, what I'm referencing is the actual acquired assets that New Bedford Medical Associates was substantially all of its assets were acquired by SPG.
But not all.
But not all.
Right.
You know, if the panel were to pay close attention to what was excluded, essentially it was a couple pieces of furniture from one of the doctors.
What about the liabilities?
Yes, Justice Meade. So with regard to the liabilities, how the asset agreement functioned was that it listed 21 contracts that it was assuming the liabilities for, and that's in a schedule that comes in the actual amendment to the asset purchase agreement in June of 2014.
And none of those contracts were this doctor, right?
Yes, that's accurate. And in fact...
And they were expressly excluded.
Yes, where those contracts were highlighted or where they were mentioned in the asset purchase agreement was actually in the schedule that describes the contracts that NBMA was subject to at the time it sold its assets to SPG. From the point at which the asset purchase sale went through, no medical services were being provided. There were no non-physician employees. There were no physician employees. The actual asset purchase agreement, how it describes that is that that particular employee that you had referenced, Jane Zykowicz, she was only simply left on in a contractual manner at the fair market value to wind up the actual affairs of the business.
How long did that take?
From the record evidence available, the actual vote authorizing the dissolution happened within about a month of the asset purchase agreement being signed, and 15 days prior to the amendment, which was June 1, 2014. Jane then, 2 years later, filed the annual reports for 2014, 15, and 16.
In what capacity did she do that?
It's unclear from the record evidence, simply because at the time she was employed by the successor entity, South Coast Physicians Group, in that capacity as Director of Business Operations. And in other words, the documents filed with the Secretary of State didn't indicate an affiliation.
It didn't indicate what her title was at that time?
It did not indicate the affiliated title in those documents. We do know that 2014, 2015, 2016 were all filed within 16 minutes of each other, and then about approximately a month later, the actual entity was dissolved itself. From a factual standpoint, with regard to the record evidence, New Bedford Medical Associates, though it may have been open or those annual reports may not have been filed for 2 years, the business was not operating. One of the items that also was purchased in the asset sale was actually the name of New Bedford Medical Associates, the phone number, the actual physical location. Doctors that had been shareholders in New Bedford Medical Associates and then were hired by SPG as doctors continue to...
Not in any management role, just as employees.
Yes, and I think that's the principal issue that's before the panel today. I did extensive case research to see if there was ever an instance in Massachusetts where the court has been able to find this de facto merger exist in the absence of this management shareholder type thought that you bring up, Justice Meade. And unfortunately, there is not any case law, directly on point showing that. What I would draw the panel's attention to is the reality of the de facto merger being a factorial analysis, and that our Supreme Judicial Court has said, no one factor is necessary, no one factor is required, and it's a balancing of all of the factors that exist.
Well, what standard of review are we applying to Judge Cowan's decision?
The standard of review would be de novo.
Is de novo?
Yes, my understanding, because it was an appeal from a summary judgment, which I've cited in my brief, the reference.
Judgment's certainly de novo. I didn't know if there's any deference we owed her on the determination of the factors in whether a de facto merger occurred.
Nothing that in my case research I came up specifically addressing that. The de facto merger, how it seems to operate in the case law I did look at, is it is that factorial analysis, and the lower courts do that weighing of each factor as to the parties. And it would be appellant's primary position that even without the shareholder factor, that the other factors weigh heavily enough that this court should reverse the decision of the trial court, send it back on down, and yes. If the panel has no further questions, I would conclude with just my prayer of relief.
Thank you.
We pray, sorry, I have this written down, this court reverses the trial court's order granting SPG's motion for summary judgment. Thank you.
Thank you very much.
Good morning. Members of the panel, may it please the court. My name is Linda Morkin. With me is attorney William Egan. We're from the firm of Robinson & Cole, and we represent the defendant appellee, South Coast Physicians Group, or SPG.
How do you see the four factors?
Can I just back up a step, Justice Desmond, which is under Massachusetts law, when you look at successor liability, that's a four-factor test too. And there you're looking for express or applied assumption of a liability. Here we know that that is not true. As Justice Meade pointed out, this wasn't explicitly excluded liability. The second factor is fraud. There was no allegation of fraud in this case either. So that leaves us with de facto merger and the mere continuation theory. The general rule in Massachusetts is there is no liability for a successor corporation unless one of those four factors is found. So I understand here the appellant is really focusing most on the de facto merger prong. There has been discussion in Massachusetts cases about the similarities and the overlap between de facto mergers and continuity. But the difference appears to be that with a de facto merger, you're talking about two companies coming together and moving forward. Mere continuation, you're looking at just one company that has reorganized or reconstituted itself into a slightly different entity. I think one court talked about that, it's the same as the old entity but wearing a new hat. So what we're looking at here is the de facto merger.
And so what's the harm that's trying to be protected in either of those?
What the courts are truly looking at with the issue of successor liability is a continuity of ownership, of control of an entity, and also inequitable misconduct. That's why you see cases that talk about fraud and fraudulent conveyances. Here, this was an arm's length transaction by SPG, which was a large, thriving physicians group, more than 300 physicians, that was acquiring this smaller practice. Arm's length transaction, detailed asset purchase agreement. The plaintiff, Dr. WEINSHEL, as a member of NBMA, which was acquired, knew about this and decided to leave the practice rather than join SPG. So he was well aware of the process of negotiations. He shared in the profits that, and as a shareholder of NBMA, when this transaction went through. Before he withdrew, he executed with NBMA two agreements, a separation agreement and the records agreement. And it's those agreements that he is suing now SPG on, even though SPG was not a party to those agreements. His main area of complaint has been that in the months after he left NBMA, when he asked for records, he received records, but either not in the format that he desired or incomplete records. He went back and forth with his former CFO about receiving these records. And the appendix shows a variety of requests, a variety of emails back and forth through 2014, after the transaction had been closed, and into 2015. NBMA stayed active. It had retained rights to its own accounts receivable, and as part of the APA, it remained active for another 2 years. It was not until 2016 that NBMA officially ended. And it was that same employee, Jane Zykowitz, used to be the CFO. Now she's just a regular employee of SPG, but they had agreed to allow her to wind up the business of NBMA for 2 years, including working, with these requests from Dr. WEINSHEL. Also, the APA actually said that NBMA would have access to those patient records for 7 years following the transaction. So at all times, SPG understood that this was a responsibility that NBMA had to the plaintiff and made allowances in order to have that happen. So one thing I think I have to make clear to the court is when we're talking about continuation, either under the 4 factors of successor liability or under de facto merger, when they talk about continuity, it's not about continuity of the business. They're looking for continuity of control. That's why you see that the very first factor is continuity of management. Are the same people going from the old company to the new company? One of the cases in Mass, I think it's Cargill, the president, the vice president, and the treasurer of the old company became the president, vice president, and treasurer of the new company. The second prong is you're looking at continuity of shareholders. Who owns the business? Who is going to profit from changing whatever this corporate structure is? And Justice Desmond, that goes back to the harm, which is, are you allowing owners of a business to avoid their liabilities to not pay their unsecured creditors by changing clothes, putting on a new dress and a new hat. Oh, now we're a new company. That's the case, that's what the cases are looking for. That's what they're examining. And what we have here is no continuity of management. All of the physicians from NBMA went over to SPG as employees. None of them had any management position. Out of the 7 directors of NBMA, one, Jane Zykowitz, the CFO, became management at SPG, but in a lesser role than she had been. She now reported to SPG's CFO instead of being the CFO. So all of this shows us that, in fact, this was an arm's length transaction. SPG was aware of NBMA's obligations to the plaintiff, but did not assume them explicitly, and provided things in the APA to allow NBMA to satisfy those obligations to Dr. WEINSHEL. When he came to court literally 5 years after these record requests, this wasn't about obtaining the records. His suit is for damages and for treble damages. That's the relief that he was seeking when he went to the Superior Court. So just in closing, I'd ask this court, if it has any concerns, contrast the facts of this case with the ones where successor liability have been found, specifically the Cargill case. That was a case where a home heating oil company was acquired, kept all of the outward indicia of being the same as the old company, and just continued on its operations, but trying to discard a significant debt to a creditor. I'd also tell you to look at the Acushnet decision, which also is that idea of having middle management go from the old company to the new company. There, the new company assumed all liabilities except for liability for PCB contamination. And the court found that very, very telling. The only thing left behind was the one thing that they knew that the old company would likely be sued for. So unless there are any other questions, this was an appropriate summary judgment. No genuine issues of material fact. The law of Massachusetts is very clear on successor liability, so we ask that you affirm that judgment.
Thank you. Thank you both.
Thank you.
Our last case is 22P123, Coyne versus R.J. Reynolds Tobacco Company. Mr. Roth.
May it please the court, Yaakov Roth for the appellant R.J. Reynolds. Your Honors, there are basically 3 questions presented by this appeal. First, was Reynolds entitled to a directed verdict on the counts? Second, if Reynolds was entitled to a directed verdict on at least one of the counts, does the punitive award then have to be vacated? And third are the questions relating to the calculation of interest, and in particular, prejudgment interest. I'll try to spend a few minutes on each set of questions.
Did you begin with the advertising to minors?
Yes, that's actually
the directed verdict.
That, Your Honor, that is where I was planning to begin.
And then reversed.
Yes, yes. So I was going to start with the negligent marketing count because that is the one where the trial court actually originally agreed with our position that there was insufficient evidence, granted a judgment notwithstanding the verdict, but later reversed course. And respectfully, we think the judge had it right the first time. The basic problem was that the plaintiff did not establish a link between the youth marketing by the defendant on the one hand and Mrs. Coyne's injury and death on the other hand.
And so the judge said that he didn't have the benefit of the transcript when he originally decided that issue. But then when he did, he pointed to, I want to say, Mrs. Coyne's sister, who testified that they had watched some of these TV programs back when they were youngsters, and I think the testimony from also the babysitter, who said that Mrs. Coyne had read some magazines where the advertising was very prominent within the magazine. So what was wrong with that?
So let me walk through the different pieces of evidence that the trial court in the subsequent order and the plaintiff on appeal points to, and sort of explain why I don't think that fills the gap that they needed to fill. Okay. So first, there was testimony at page 4310 of the transcript that Mrs. Coyne had seen an ad for the Marlboro Man. That was one piece of evidence. Of course, that's a different company. That has nothing to do with Reynolds. Reynolds didn't manufacture Marlboro, and that's not related to our conduct. So I don't think that can sort of fill the gap there. The second thing that the trial court really emphasized was that Mrs. Coyne had repeated a Winston slogan as an adult. Winston is the product that we manufactured. But that, I don't think, says anything about when she heard the slogan or the impact it had on her. And there was evidence that that slogan continued in use until at least 1980, when Mrs. Coyne would have been 23 years old. So for many years, when she was not a minor, that was a prominent slogan. So I don't think that can tell us that she heard youth marketing as a minor and made the decision to smoke based on that youth marketing. The trial court also emphasized the expert testimony, which was that these ads were very prevalent, you know, if they're all the time on TV and in magazines and so on. But respectfully, you know, I don't think under the SJC's really seminal decision in that bus case, Smith, that kind of statistical sort of generality can't substitute for kind of particularized, individualized evidence relating to the plaintiff.
Does it matter that the expert testimony in this case appears to have been more ground covering or more definitive than it was in Smith? For example, saying it's virtually certain that?
Yeah, that's one point they make in their brief. But, Your Honor, if you look at particularly the sort of scholarly examination of that decision, it's pretty clear that it's not about a particular threshold. It's about the type of evidence, and is it particularized or is it completely generic? And the idea is, if you want to have a verdict where the defendant has to pay, you know, many millions of dollars to the plaintiff, we need evidence about the plaintiff. We can't just rest it on even a high likelihood of sort of statistical generality about, you know, an ordinary 16-year-old or 14-year-old at a particular time.
That's what Smith says? I'm sorry, that's what Smith says?
Smith is, yeah, that's right. Smith stands for that proposition. That's the case with the bus. And they said, well, you know, here's the evidence that the only company that had the right to have a charter for a bus at that time on that street was this company. So we can assume that that's the bus that hit the plaintiff. And the SJC said, no, we can't do that. We need actual testimony, we need actual evidence, a foundation for a determination that this particular accident was their bus, not just, you know, it's likely based on, you know, the number of buses on the street at the time and who owned them.
They're saying, and Mr. Bogdanow can correct me if I have it wrong, but the market is saturated with this advertisement to the point where it's more than a statistical probability that she was exposed to these ads. And you would say to that, okay, but how did that influence her decisions?
Yeah, I think there's 2 points, Your Honor. One is you need 2 things: that she was exposed to it and that it affected her decision. Right? We don't actually have either. You do have sort of the statistical testimony on the first. You don't have anything on the second.
So as to the first, they said virtually 100% certain that she was exposed to it,
yeah,
right?
and that's right, Your Honor. I think the problem I have with that is if that is enough, then anybody who took up smoking as a youth would be able to get to a jury on this claim without any particularized evidence about their experience. And I think that can't be the law.
Well, putting this, sorry.
So your quarrels with the weight of that evidence?
I don't think it's the weight, Your Honor. I think it's the nature of it, the type, that it's generalized and not particularized, to me, is the important point. And then also the link, this is related, the link to the effect on on her. And really, if you go through the testimony, every witness who knew Mrs. Coyne, her children, her sibling, her husband, and so on, they were all asked the same series of questions. Did she ever tell you why she started smoking? Did she ever tell you why she started smoking Winston's? Did she ever tell you that she saw an ad for Winston's? Everyone said, no, she never said that to me, she never said that to me. So there's a total absence of evidence on that kind of critical point of causation. And I get it, it can be hard to prove, particularly when the individual has passed away and her testimony wasn't preserved in any way. But again, if we're going to require a defendant to pay a very large sum of money to a plaintiff on this count, I think the law does require some sort of evidentiary foundation to allow the jury to make the critical inference that she was both exposed and that the exposure to that advertising influenced her decision.
Could I just ask one more question? And again, dead horse beating is my forte today, I guess. But with respect just to the Smith issue, does the testimony about Mrs. Coyne's having seen the Marlboro ads not tie her into the group of people who saw the nearly 100% saturation level advertise? I understand the causation issue is a separate point, but at least as far as that argument about whether she happened to be one of the people who was exposed to this advertising, does that not make a difference in that level?
Well, Your Honor, I mean, it's relevant. It could be relevant evidence to certain counts. I'm not sure it really helps on this one because of the fact that it's not the right company. There's also no evidence that the Marlboro Man, whatever she saw about the Marlboro Man, was targeting youth, right? I mean, the theory of this is there were particular ads that were targeting youth, either because they ran on children's TV shows or for other reasons, that she was exposed to those by Reynolds and that they influenced her. And I just think, yes, there's the Marlboro Man, there's the slogan as an adult, there's the statistics, but I don't think it connects the dots sufficiently to allow the jury to make the finding that it needs to make on this count.
Did Winston have a strategy? Isn't there evidence that Winston had a strategy to target young kids from 14 to...
Right. So that was the fourth point that I was going to get to on my list of bullets of what they rely on. And the fourth is yes, they try to shift to say, well, this was intended, right? This was Reynolds wanted this. But that's evidence about the defendant's subjective intent. That's not evidence about what happened in objective fact with the plaintiff. So again, I don't think that gets you there, right? Again, if that were enough, all you'd have to do is say, so-and-so smoked, was injured as a result. Here's this bad stuff the defendant did. Go to a jury. And I think you need to have that connection. The law requires you to have that connection in order to take that step of supporting the verdict.
All the arguments you're making right now were made to the jury?
Yeah, I mean, the arguments were made, and the question is, was there enough for the jury to draw that line? So it's not an instructional, we're not making an instructional argument here. It's an argument about the sufficiency of the evidence. And again, the trial court, at least initially, did see this defect that we pointed out before switching positions on it. On the second count, I'm not going to repeat the whole thing again because it really is a pretty similar idea. This is the conspiracy misrepresentation count. And again, it's really the same defect, which is there's evidence of misrepresentations by the conspiracy, but there's no evidence that Mrs. Coyne, heard those misrepresentations or believed them or acted on them. And they need actually all three of those things to get to the judgment. On this point, I'll say the principal emphasis of the trial court was the material about light cigarettes. And there was evidence that Mrs. Coyne switched to light cigarettes in the late 80s because she thought light cigarettes were safer. And so that's what they really hit on this point. The problem with that is their own experts repeatedly testified that the statements about the relative safety of particular brands or types or designs was outside the scope of the conspiracy and in fact would have violated the conspiracy because it would imply that other cigarettes were more dangerous. And so they said the conspiracy didn't ever take a position on A versus B. It had to be about cigarette safety generally. And so That, by the way, is at pages 1562 and 2195 of the transcript. They're experts saying this, and so this is a conspiracy count. They need to point to something that was a misrepresentation by the conspiracy, and the material about lights couldn't have been. It also couldn't have caused her injury, because switching to lights is not what caused her to get sick and to die. She was already smoking for 20 years before she switched to lights. So that whole theory it would make sense in a case where somebody initially started smoking lights because they thought, oh, this isn't so bad. But somebody who's already smoking full flavor and switches to lights.
I mean, she had not contracted cancer until she started smoking the lights one.
That's right, but there's no evidence that had she stuck with the non-lights, that she would have avoided that harm.
What about the reasonable alternative cigarettes?
Yeah, so that goes to the breach of warranty count, so that's the third count. That's really a distinct kind of problem. I'm not sure I have fully enough time to cover it, but the plaintiff does have an obligation to identify a reasonable alternative design that is both a cigarette, not some other product, and safer. We don't think they did that. They have three different theories. We sort of outline in the brief why we think each one fails for slightly different reasons.
They cite some federal statute about what a cigarette is.
Yeah, but that's a regulatory issue. That's not really related to the product liability issue before the court, which is, would a consumer treat this as a reasonable alternative? Right, that's the question. And they say, oh well, you could have something that's not inhalable, right? But if it's not inhalable, it's not a cigarette. That's a cigar, right? That's the key difference.
Says who?
Says their expert, actually. Their expert said a cigar, the key thing that distinguishes a cigar from a cigarette is the inhalability. It's 882 and 2050 of the transcript.
Wasn't there some evidence of non-inhalable cigarettes that were?
I don't believe so, Your Honor. I think there was some evidence of something that you don't burn. This is their second alternative, the heat not burn. There was also testimony that the consumers didn't treat that as a legitimate cigarette because it is so distinct in how it operates.
So the issue of the inhalable cigarette came forward with the low nicotine?
The low nicotine is the third version. Yeah, the low nicotine, yeah, that's right. There was evidence of the low nicotine. The problem with low nicotine is nicotine isn't what causes the injury. Nicotine makes it addictive, right? But the defect, what causes the cancer, is the tar. So lowering the nicotine doesn't actually make it a safer cigarette. It may make you less likely to use it, but it doesn't actually make it safer. And so that's our issue with that. Your Honor, I just want to, if I could, I'm hoping to use the last few seconds, if I can, to at least touch on the prejudgment interest issue, which is, I think, an important one.
Is that at the SJC, that issue, or part of it?
So the rate issue is at the SJC, and I'm not going to waste the court's time with that. That will be decided. It was argued last month in a case called Green. But on the future damages point, the SJC decision in Conway, which is the principal one we cite, pretty clearly says prejudgment interest, there's no basis to apply it to future losses because you haven't you haven't felt that yet. There's no reason to give you interest predating the judgment for something that hasn't happened yet. And one of the line items here, the loss of services and companionship, was predominantly a future loss, dating 20 years, into the future. And I just don't see how that granting prejudgment interest on that amount can be squared with Conway and all of the arguments they give. The statute says it, and the Carey case. All of that is irreconcilable with Conway, which itself says that, notwithstanding the statutory text, there's no basis to apply it to future damages, and that this specifically distinguishes the prior case in Carey that plaintiffs rely on and say that reject the overreading that they give. I apologize for going over.
That's okay. Thank you, Mr. Roth.
Thanks for your time.
Mr. Bogdanow.
May it please the Court, Your Honor, my name is Michael Bogdanow. With me is Andrew Rayner from Public Health Advocacy Institute, and with co-counsel we represent James Coyne, the representative of the estate of his deceased wife, Pamela Coyne. I'll focus heavily on the causation issue because I know that's important. Before I do, I'd like 1 minute on what Reynolds is not contesting on appeal because I think it's important. They are not contesting the sufficiency of evidence of the conspiracy. They're not contesting the sufficiency of the evidence of a decades-long conspiracy that lied to the public about the addictiveness of cigarettes, about the health impact of cigarettes. They're not contesting the sufficiency of evidence that the conspiracy in Reynolds kept nicotine at a level enough to addict people, and they're not contesting that Pamela Coyne was right smack in the middle of the age group that the conspiracy in Reynolds was going after.
But they do seem to contest that Mrs. Coyne was not aware of any statements made as part of the conspiracy.
They are disputing causation on that level and on a couple other levels, and they're just wrong on the evidence. First of all, there is evidence, which the court just addressed briefly with my brother. There is evidence that Mrs. Coyne was exposed to the advertising. There's evidence of that because it wasn't just almost 100% certain. The testimony was that it was 100% certain that someone of her age would be, with a television in their home, would be exposed to it.
Whose testimony was that?
That was the expert testimony, and also
the expert testified that she was exposed to this?
That it was 100% certain that a teenager in the 60s and 70s with a television in their home would be exposed to advertising. And now it makes sense, Your Honor. At that point in time, the cigarette, all the conspirators had roughly 50% of television shows under their sponsorship.
Wouldn't you have to also show a connection that, given that exposure, this caused her to smoke Winston's and caused her death?
So what we have on that, Your Honor, is, well, number one, on warranty and on the 93A, the answer to that question is no, not exactly. But we'll come back to that because the focus of my brother and this court was on the negligence case. What we have on that is that we know that the teenagers in her teenage years were the primary target of Reynolds and its co-conspirators. We know that, and there was evidence of that. We know that they later congratulated themselves on having succeeded. We know that she spent her life saying Winston tastes good like a cigarette should, which was primarily their advertisement through her teenage years, and yes, it overlapped until she was about 23 years old when they took that off the market. So we know that. So
was there any evidence that she recited that phrase when she was a youngster?
The testimony on that is that was from her husband. So it was in her early 20s, and from then on, for the rest of her life, she recited, Winston tastes good like a cigarette should. They got their message across. They did it. They had that message throughout her youth. They advertised that on the Flintstones and the Beverly Hillbillies.
I get it, but that messaging was still happening when she was an adult, right?
Yes, and it was, well, it reinforced, the messaging was reinforced until she was in her early 20s when they finally yanked it, and then she said it the rest of her life. Could a reasonable jury infer that when their goal was to get her as a teenager, that was their goal, when they advertised 151 million kids under the age of 12 were exposed to that advertising every week, that evidence was in the trial. They succeeded. So could a jury reasonably infer that her reciting that jingle didn't just begin when she turned 23, but it was the reinforcement from the time she was 6 years old and then for the rest of her growing up? In 1973, Pam was 16 years old. Winston was one of 3 primary contenders in the quote-unquote youth market, which they defined as down to 14 years old. They succeeded. They got her. And they were happy about it at the time. And internally, it's in our brief, internally they claimed success. And now they say, oh no, we didn't have anything to do with her smoking. I'm sorry, a jury could reasonably infer that, yes, they did have something to do with her smoking, and all we had to do was prove it was a cause of her smoking, and that was enough for the jury inference. Let me briefly touch on warranty. I don't know why my brother just said our expert testified that non-inhalable cigarettes are not cigarettes. Our expert testified that inhalation is not a requirement of cigarettes, and that it's not part of the definition, and that the definition is any tobacco rolled in paper. The difference between a cigarette and a cigar is that a cigar is rolled in tobacco, and a cigarette is rolled in paper. And our expert at transcript volume 2, pages 2056 to 59, expressly testified that, yes, a non-inhalable cigarette is a cigarette. Their own vice president testified that the heat-not-burn cigarettes, Dr. Figler, are cigarettes, their own vice president and authorized representative. And then lastly, the very low nicotine cigarettes are wrapped in paper. My brother doesn't even contest that they were cigarettes, but my brother says very low nicotine still has nicotine. The expert testimony was that Reynolds kept the nicotine level of its cigarettes to be addictive. That was what they were all about, while claiming, of course, that cigarette smoking wasn't addictive. But that very low, meaning down to about a 0.7 or below that on a scale, would mean you wouldn't be addicted. And what was the expert testimony on that? It was that it would make it much more likely you'd either quit or reduce your smoking, it would be much less hazardous, and it would be a safer cigarette. That's why this court, in the main case, came out to the conclusion that all three of these were safer alternatives. And then my brother says, well, even if they were cigarettes and even if they were safer, because they're not disputing the defectiveness of the cigarettes. They don't argue that on appeal. Then they say, well, it was too late to help her. They're turning the table around here. First of all, the expert testimony, Dr. Reynolds, was that it was not too late to help her. It was every year she smoked increased the chances of her succumbing to lung cancer, all the way up until when she was finally diagnosed in 2015, 1 year before she died. Every decade she smoked increased her chances of succumbing to lung cancer. The 60s, the 70s, the 80s, the 90s, and all the way up until 2015 when she was diagnosed. So could a jury infer that if they had quit selling their defective, dangerous, addictive cigarettes and instead sold the safer alternatives, that would have been better for Pam Coyne and reduced the likelihood of her succumbing to lung cancer? Of course a jury can infer that. And the Supreme Judicial Court has even said, we don't have to prove that she would have smoked them. She could have tried them and not liked them and not smoked them. That's not the issue. The issue is if there was a safer alternative, Reynolds should not have been selling its addictive, dangerous cigarettes. The 93A is similar to that. Judge Wall could have simply based his opinion on something that he did recognize, the breach of warranty, which is virtually not disputed in this case, was enough to support the 93A finding. And he recognized that. He went further and he addressed all the issues that I've just raised. But even if he had limited his decision to the 93A, that was enough to support the breach of warranty. That was enough to support the 93A decision. And similarly, they say, well, but how do we know it would have helped her after 1979? Because that's the only conduct relevant to 93A. Well, the expert testimony, that's how we know. Because the expert testimony, as I've just explained, was that every year she smoked increased the likelihood of her succumbing to cancer, which she didn't do until a year before she died in 2015.
I'm going to interrupt you for 1 second. Did her smoking increase when she switched to lights?
It did increase when she switched to lights. And my brother says, we don't know why she switched to lights. I don't get that, Your Honor. The testimony was she switched to lights because she thought it would be safer for her and make it less likely, more likely that she would quit, when in fact the evidence was, it's addressed in the brief, that by compensation she actually increased her smoking when she switched to lights. Similarly, the evidence was she started smoking Winston's because they had filters. And her husband said she thought with the filters they'd be safer. But the tobacco industry knew filters weren't doing anything. And as far as lights and the conspiracy, it's been well recognized, Judge Kessler in the landmark decision of the United States versus Philip Morris, that lights were part of the conspiracy. And there was expert testimony at this trial that lights were part of the conspiracy. Lights were invented by the conspiracy. That's transcript Roman numeral 2, page 1499 to 1500. So lights were part of the conspiracy. Were they competing with each other about it? Not necessarily. They were all on board with this lights fraud. Punitive damages. My brother primarily says, well, there may have been something wrong with the negligent marketing case, and therefore we don't know if that was the basis for punitive damages, citing Evans. There's so many reasons why that is not accurate. Number one, Evans, the problem was that there was inadmissible evidence that might have supported the punitive damages. There was evidence of marketing to African Americans. And the Evans court said, but your claim was marketing to minors. That evidence should not have been admitted. And we don't know if that error impacted the punitive damages finding. And there weren't separate questions asked. There was only one, gross negligence and intentional misconduct. So it had to be sent back on that ground. My brother doesn't raise any issue of admissibility of evidence. No issue on the jury instructions. And we are the ones who asked for separate questions. My brother's, Reynolds, asked for a single question, contrary to Evans. The plaintiffs insisted on separate questions. There was a negligence question, breach of intentional misconduct question, and the jury found yes on both. So we now know that, yes, gross negligence might tie to the negligent marketing, which we think was fully supported, but there's also the intentional misconduct yes on the punitive damages. So we have the separate questions, and the punitive damages verdict was fine. I see that I have a teeny bit of time left on interest. It's interesting. My brother says that these wrongful death damages are mainly future losses. Well, there's a problem with that argument. The wrongful death statute ties in to the prejudgment interest statute of 12% added to the entire verdict. Why would Chapter 229, Section 11 of the wrongful death statute impose prejudgment interest only to take it away because most wrongful death damages are for future losses? It makes no sense. This court addressed it in Cuppins and rejected that argument and said Conway is a very narrow exception to prejudgment interest, and it is limited to employment discrimination cases, and even then to front pay damages only. It is not a problem with personal injury or wrongful death cases, and my brother's argument would render Chapter 229, Section 11 a virtually irrelevant statute, and that makes no sense. In closing, Your Honor, this jury sat through 20 days of a trial. It didn't just issue an impassioned or biased verdict. It answered many questions which can be found at the end of Volume 1 of the appendix, and it included different findings on conspiracy. It rejected one of the conspiracy claims and accepted the other. It found Pam Coyne heavily at fault, 49-point-something% at fault, and Reynolds 50-point-something% at fault. This jury was nuanced and thoughtful, and it came out to the same inference that Reynolds came out with, which is that Reynolds succeeded in convincing this teenager to smoke, and like 50% of her age group, she became a lifelong smoker and succumbed to lung cancer. Thank you, Your Honors.
Thank you. Thank you both. We'll take it under advisement. With that, I'd like to thank my colleagues, the court staff, our court officer, our excellent timekeeper, and we will stand in recess.
Nice to meet you, Jakob.
Was that now? Yeah, no, I know. Thank you, sir.